Good afternoon, everyone. Thank you so much for joining this Smart Protein Industry Forum webinar on advertising smart protein products, practices, and regulatory challenges. This session is one of the various consultative initiatives we are conducting as a part of the industry forum set up by GFI India to gather inputs from industry for representation to the government and build awareness about the policy and regulatory developments that have a consequential effect to the alternative protein industry. Some of you have been a part of our earlier discussions, and we welcome to the new participants to share their inputs through this platform and with the policy unit of GFI India. Through the forum, we work to convene entrepreneurs, investors, corporations, and other stakeholders to unlock major bottlenecks and ease industry-wide challenges in the smart protein sector. This session will be co-conducted by the policy team of GFI India and one of our regulatory advisory council members, SS Rana and Company. From the policy team, we have with us our Astha Gaur, policy specialist, and I, Ojasvi Uppal, policy fellow with GFI India team. From SS Rana, we have Rupin Chopra, associate partner at SS Rana Company, as part of our regulatory advisory council, and we will take a bit more about we will talk a bit more about that in a minute. And now let Rupin introduce himself.
Hi, good evening, everyone. My name is Rupin, as Ojasvi has already informed about the basic details. So I'm an associate partner practicing law for almost 11 years now, and very proudly associated with GFI as a council member. And I would also like to thank GFI for giving me the opportunity to be part of today's webinar on regarding the about how to advertise your smart protein products, wherein we would be covering various different topics from the FSSAI, the ASCI, and the intellectual property rights. So this is it, and I hope everyone enjoys the webinar.
Thank you so much, Rupin. It's a pleasure to have you with us. This webinar will be recorded. However, we will stop the recording before the Q&A session to allow stakeholders to raise any questions that they have. An advertisement is how any company communicates with its consumers. And through this informative session, we want to simplify interpretation of the laws and regulations on what can be done, what cannot be done, and what are the penalties. In this session, we will, have an introduction. In this session, we will have an introduction on what the Good Food Institute India is doing, its policy and regulatory practice. We'll also introduce you to the mini guide on advertisement and claims that the GFI India team will introduce. And Rupin will take us through the advertisement guidelines for plant-based products. I'll now ask Astha to talk a bit about GFI India's work and mission. And Astha, over to you.
Thank you so much, Ojasvi, and thank you so much, Rupin, for your very kind words. We are very happy to be associated with SS Rana as well, and all our Regulatory Advisory Council members, about which I'll talk in just a minute. Like Ojasvi mentioned, an advertisement is essentially how a company, especially a food business operator, a plant-based food business operator, as is relevant for a discussion right now, communicates effectively, truthfully, clearly about their products, about the usage of the product to their consumers, which is why it becomes essential for us to have this discussion. I feel we do not often talk about the legal compliances and the regulatory landscape for advertisement that a company needs to follow while advertising their product, which is why I'm very excited about a discussion today where Rupin, as our expert, would be leading the session. But before that, most of you already know about GFI, but we are a network of non-profit organizations focused on future-proofing our global protein supply. As an organization, we work across policy, business, and science with scientists, entrepreneurs, investors, policymakers, regulators, and other stakeholders diversifying protein sources for a more secure, sustainable, and just food system to build pathways for one of the most compelling scalable and market-driven solutions, we have to transition toward a protein supply fit for the future. Our core goal at GFI is to mobilize open source funding, foundational science, knowledge, resources, and other forms of support to accelerate the sector. Talking about a policy unit specifically, where Ojasvi and I work, it provides, but before I get to that, talking about the challenge is to feed the growing population of the world. The inefficiency of the industrial animal protein production contributes to food insecurity by competing for limited land and agricultural inputs. We know that. Bypassing the animal and processing more plants directly into food for human consumption is the only way we will provide protein to a fast-growing and still vulnerable global population. Several reports, such as Eat Lancet report, advocates for a planetary health diet that focuses on plant-based foods and reduces our reliance on animal-sourced foods. And yet, the meat demand has been rising. We believe the answer to these many issues is to take the meat, egg, and dairy products that people love and to make them in a more sustainable and efficient way. We want to meet consumers' demand for the meat they love in a way that is better for the world and better for business, and which is what most of the participants who are plant-based companies, smart protein companies who have joined right now are working on. In India, we refer to this theory of change as smart protein, also known as alternative protein. If we can have the next slide, please, which is enabling a global protein diversification. GFI India defines smart protein as products which can reliably and predictably substitute the consumption of animal-derived meat, eggs, and dairy because they perfectly replicate the sensory and cultural experience for consumers and offer several advantages in the supply chain for producers. In our definition, alternative protein includes plant-based, fermentation-derived, and cultivated protein. I'm certain you're already familiar with plant-based, which has been much discussed, much talked about. These are products which biomimic meat, eggs, and dairy using plants as the building blocks, since plants, like animal products, are composed of protein, fats, vitamins, minerals, and water. There are over 1,000 startups within this segment, and most leading food and meat companies have launched or acquired brands. Fermentation has been emerging in recent years as a key enabling technology for the alt protein or smart protein industry that allows the production of standalone protein sources or functional ingredients such as microorganisms, such as filamentous fungi and bacteria. This is an emerging field in smart protein with a little over 50 startups developing B2B and B2C products globally, with another 30 or so companies with fermentation initiatives for animal-free proteins. Lastly, we have cultivated meat, which basically is real meat grown from cells outside of an animal. It's also a new field, but with over 70 startups globally, and likewise participation by 40 or so life science companies with initiatives in this space. While I've been speaking of these three categories individually and separately, it's worth noting that in the future, we expect these three categories to coalesce into one large industry where we produce animal product alternatives using techniques and ingredients from multiple technologies. Next slide, please. Talking about GFI India's policy and regulatory unit and practice, our policy unit provides strategic advisory to government agencies and regulatory bodies through industry representation, comment letters to establish clear regulatory pathways for the industry. We convene consultations and information sessions with scientific and industry stakeholders as a part of GFI India's industry forum, such as this one, to educate the ecosystem about emerging regulatory developments and also to consolidate current concerns and bottlenecks to communicate to the policymakers. We have engaged with and provided inputs to several members of the FSSAI on several regulatory frameworks and work closely with various industry bodies such as FICCI, CII, able, etc. Internationally, GFI works closely with key regulatory agencies and government bodies to help develop standards and guidelines for alternative protein industry. GFI has also been granted an official observer status in the Codex and has been working closely with the body to set standards for emerging food categories. The policy team and the regulatory unit within it undertakes a wide varieties of project, which is built at aiming regulatory pathways for alternative proteins. And to do that, we regularly engage with the Food Authority in India, which is the FSSAI, and make representations. We also provide one-on-one and other forms of advisory to companies on their legal and regulatory queries. And for this purpose, GFI India has established and primed a regulatory advisory council. SS Rana is one of the members of Regulatory Advisory Council, which provides focused regulatory advisory to the industry and to also shares inputs with the regulator along with us to establish a clear regulatory path to market for smart protein sector in India. The council consists of legal and regulatory experts across who have expertise across intellectual property, food regulations, corporate and commercial, and other legal areas as well. These experts have experience across these legal areas and other compliance and support us in supporting companies with their compliance requirements, answering their legal queries, as well as supporting them with any legal requirement that is needed to operate a food business in the smart protein sector in India. With that introduction of GFI India, its policy unit, as well as the Regulatory Advisory Council, I would like to invite Ojasvi again to talk a little bit about the release of advertisement mini guide.
Thank you so much, Astha, for introducing everyone to GFI and their ACT members. All the participants of this webinar will have an early access to the mini guide, which the GFI India team will be introducing early next week. This mini guide would provide an overview of the regulatory and legal framework as a tool for companies to navigate advertising and claims-related compliances. This mini guide covers the general principles of advertisement and claim regulations 2018, some understanding of how the claims are categorized in this regulation, as well as how they apply to your product. There's a separate section for the vegan foods regulation, which were released last year and are being enforced actively by the regulator. There's also a special mention and the section for the ASCI code, which has specific requirements for the food and beverage companies to comply with. I would now like to invite Rupin to take us through the advertisement and legal landscape in India. After his presentation, we will take all your question and answers. Please feel free to put them in the question and answers tab at the bottom of your screen. Thank you. Rupin, I'm handing over to you.
Thank you so much, Ojasvi, and thank you so much, Asta. Ojasvi, would you please help me in displaying the PPT? So meanwhile, I would really appreciate all the people from the industry who have joined the session today, because I know it's a business day and we are closing on the weekends, and it's amidst, it's only 4 p.m. and I really appreciate everyone joining this session. And thus, I would not try to take a lot of time of yours, and I would not be only talking from the perspective of a lawyer, but I am here with few examples as to what would be construed as a legal advertisement and what would be considered as an invalid advertisement. Next slide, please. So as part of the presentation, I have divided the topic into 5 categories today. The first 2 topics are pertaining to the guidelines which have been issued by the ASCI for supporting and limiting the claims, misleading advertisement and endorsements. The 2018 FSSAI advertising and claims regulations and guidelines for influencers, and finally, but importantly, the Trademarks Act also, because trademarks do play a very important role in the advertisement sector as well. So just for the sake of clarity, you would note in the PPT that I have put in few images of different brands and celebrities That is just clarifying that I'm using it under the doctrine of fair use of the Copyright Act, and I'm not making any commercial gains out of it. So this is fairly permissible. So let's start with the guidelines for prevention of misleading advertisements and endorsements, 2022, issued by the government. Next slide, please. Yeah, next one. Yeah, thank you. So as you can see, and this particular guidelines to all the advertisement which are done in any form or format or any kind of medium, be a social media or a print media. So it is applicable everywhere, and it applies to everyone who is into the food industry, including the manufacturers, the service providers, the traders who advertises, advertising agencies, and the endorsers who engage in the advertisement. So any and all kind of companies who are engaged in advertisement of their products, including the plant-based products, have to strictly adhere to these guidelines to avoid any liability in future. Next slide, please. So starting with the valid advertisements. So valid advertisements, they are the most important fundamental principles of our business, because and the only underlying the basic underlying principle here is that the advertisement should be truthful and it should be an honest representation of the product, and there should not be any misleading to the consumers at all. As you can see from the image which I've put in, if you put up an image of a product which looks like a burger looking in the expectation column, but in reality that is generally not considered as a valid advertisement, and it should not be exaggerated, and it should not be misleading with the unsubstantiated claims. So whatever claims we are putting in on our products, we need to ensure that they are backed up with some scientific evidence or some other evidence, so that tomorrow, if any complaint by a consumer is filed or any challenges put up by the FSSAI about any of our claims, then we need certain documents to prove our claims before the court of law. And not only this particular guidelines, we also need to be compliant with the other specific laws. For example, the legal metrology laws, those are also applicable on the food products. There are certain 8 to 10 declarations which need to be mentioned on the packaging of the product. Then there is a sizing and the numeral requirement which is there in the law, which we need to also adhere on the packaging of the product and on the labeling also. Next slide, please. So the ad should not present any claims which is a universal fact. So here I have put in, instead of talking on the law in this slide, I have tried to put in some scenarios here. For example, if a plant-based beverage company advertise the health benefits of the product and claim it can significantly lower the blood pressure without any substantive research, in that scenario it would not be considered as a valid advertisement, but it would not be considered a valid one, because whatever the claim which was made, of course, the FSSAI Claims and Regulations Act 2018, they do permit us to make any and all sorts of regulations, provided they need to be backed up by substantial evidence. In this particular case, about the health benefit of the particular product, it was not substantiated by a particular research. The second one would be a company creating a fizzy plant-based drink, claim their drink can prevent cancer. But again, that happened without the scientific evidence. Again, just for clarity, this is only a fictional example. Nothing of this sort has happened before the court of law in India. So the last one would be a plant-based kebab manufacturer claim that the customer will acquire diseases if they consume chicken kebabs. Now, this is very important for the people in the plant-based industries, that we always need to promote the balanced diet, or we can always promote our products. Even the advertisement guidelines, they always say that we are number one, we are the best, one of the best in the industry. Like, our product has these many qualities, of course, backed up by the scientific evidence. But at the same time, we should not be disparaging to anyone. Therefore, we can always say that I am the best. But I cannot say that I am best, but party B, who is my competitor, their product is bad. So we should not be making comments about any other products during our advertisements to avoid any issues or getting any complaints from the ASCI. Next slide, please. Great. So nonetheless, there are few exemptions which are there in the ASCI guidelines. It shows that If there is any product failure which is within the acceptable limits, of course, the boundaries have not been defined here, but as lawyers, we need to prove before the court of law that the failure was within the acceptable limits, and being the advertiser, a prompt action was taken to make good of the deficiency. So tomorrow, next slide, please, Ajasvi. So if any product is launched into the market and later on it is revealed that a product suffers a deficiency, and that mistake is a genuine mistake and it can be proved, then in all scenarios, the product can be recalled and a decent apology to the customers can be made to avoid any kind of liability. I have given the same example here, that a company who sold a plant-based food product to consumers, they claim that their product uses raw materials from the Himalayan region, but it was later on discovered that the materials actually came from the Deccan region. In that case, if the company on receipt of the information, if they recalled the product and apologized to consumers, so that would somehow fall under the category of the exemption. It is not applicable in all cases. It would depend upon the facts and circumstances of the case. We need to prove that the mistake was an honest one, and we are recalling the products at our own cost, and the new products or the replacement to the products will be given or has already been given to the customers. Next slide, please. Great. A free claim ad. This is one of the very common advertisement which is made by the companies. And just for the information, I have not used a lot of examples from the plant-based industry because it's fairly new, and I have not seen many cases happening there. That's why, and hopefully since the industry is growing, I hope within the next 1 year I would have some examples of good practices followed by the plant-based company. So a free claim ad is something when we say that particular product is given to you as a free of cost or free of charge. In that case, it has to be ensured that the product actually given to the customer is actually free, and we do not and we are not required, and the customer is not required to make any payment towards the packaging. And of course, if required, the cost for the delivery can be taken from the customer. So it should not be the case that an offer is floated in the market that a particular product is being given out for free to the customers, and when the customers approach the particular online store or the offline store, then it is being informed that, okay, we are only giving the raw material of the product free of cost. If you want that product, you pay us a certain X amount, we will manufacture it for you, and this much is going to be the packaging amount. So that is not considered as a valid agreement. So again, a scenario: an oat-based beverage company promises customers a free X grams pack of tofu on every carton of milk bought. In this case, the consumer knows and understands that the free product is being given in addition to the usual carton of product without any extra charge being levied. So here, the customer, upon going through the advertisement, makes up his mind that if I'm going to buy a bigger product of bigger quantity from this particular manufacturer or the seller, I'm going to get certain grams of the product free of cost, or certain milliliters of product free of cost. But when the customer goes, he definitely has developed this apprehension that I'm going to get it for free. On that case, at that moment, it cannot be informed to them that, okay, if you want the product, we will manufacture it for you, or you have to pay certain amount of packaging. So this is what free claim ad is about. Next one, please. So the next one is the, sorry, I think there is some, you skip something, yeah. Surrogate advertisement. Again, before the call, me and Asta were discussing that this was not at all relevant to the plant-based industry, but nonetheless, since I had put in the efforts to get out the pictures, so I have done it. So as you are aware that alcohol is banned in India, so this is how the companies are doing the surrogate advertising within the permissible parameters of the law. Next one, please. So the duties which are here talks about the duties with respect to the claims and the advertisement on the manufacturer, any kind of agency who is doing the advertisement of the particular product. The descriptions and the complaints and claims and the comparisons must be substantiated. For example, a plant-based company advertises their product as 100% natural and organic. However, it was found that the product contained artificial flavoring. So it is one of the duties that the plant-based companies, and even the companies who have already got it endorsed as the vegan, they need to have the traceability up to this level of the manufacturing of the product, so that there should not be any challenge that the particular claim is not valid one. Next one, please. So the sources and the dates of independent research should be supported, as I have been mentioning twice or thrice during the presentation all this while, that having a substantial backup document to support your claims plays a very important role. Again, that is the document which can be submitted to the FSSAI or before the court of law. If on any given day you are challenged by a third party or by the FSSAI that your product lacks a certain quality. Again, a simple scenario here is that a plant-based protein manufacturer claimed that the product to be scientifically proven alternative of vitamin D. However, the research was outdated and not relevant. Again, it's a duty of the manufacturer and anyone who is involved in the advertisement to ensure that such unsubstantiated claims should not be done on during the advertisements. Next one, please. Thank you. So no reference to a person or a firm or institution in a manner which confers an unjustified advantage. An example, again, a fictional name, a plant-based burger chain, Wagyu Burger, targeted sandwich club that sold meat burgers-based burgers, their aids. The Wagyu Burger claimed the sandwich lacks hygiene and sell inferior products. Again, it's a case of disparaging. We should be ensuring that we should not be disparaging anyone's products. So a very famous case law, again, not from the food industry, if I can recall, which happened in case of the GE Electricals versus Havels, wherein one of the companies were using the designs of GE Electricals, which showed that when the actor in the advertisement, he tried to switch on the particular plug, he received a shock from it. So that is what they did, was in order to promote their product, they disparaged the other party products. So that was held by the court of law to be in violation of the advertisement guidelines. Next one, please. And it should not mislead your advertisement should not mislead the customers or abuse the trust or exploit of experience. And ad should not mislead the customer through statements or visual presentations about the product. By using the terms which are ambiguous, like up to 5 years guarantees, prices as low as rupees this, you should rather clearly indicate a fixed period of guarantee or a price. And another example, a fruit juice manufacturer claiming that the juice gives customers the power to fight COVID. Again, such a claim should not be made unless it is backed up by a sufficient documentary proof. Next one, please, Ojasvi. Ads targeting the children. There are certain ads in the market which target the children, which are actually made for the children, and the ASCI has definitely given the guidelines to prevent any kind of encouraging the dangerous behavior or detrimental to the physical or mental well-being, making any claims that if you drink our beverage or if you eat our product, you will become a superhero. And during the advertisement, it is shown that the cartoon character is jumping from the building. That is not permitted. Use of any ad of junk foods like chips or carbonated drinks during children programs, it's again prohibited. And exaggerating what is actually attainable by an ordinary child. Again, making claims that if a child takes our product, he will become he will grow taller by a certain amount of inches or feet in a particular year, or making any kind of claim, making that something like eating our product will enhance your mental intelligence or physical ability without valid evidence. So these are the one of very few guidelines which have been issued by the ASCI to ensure that the advertisement does not cross to the limit which can encourage any kind of dangerous behavior or something which is detrimental to the physical or mental well-being of children. In the scenario where I have mentioned, right, it's a cartoon of Krish. Sorry for that. It's not looking too good. So it says that an oat-based drink producer claims that children who drink oat can become strong as a superhero. The superhero they showed in the ad jumped from one building to the other. Now, such kind of ad is going to trigger such kind of activities in the children, and they are definitely going to pursue their parents that we want to bring this particular product, or we want to eat this particular product, and eventually we would want to jump like the particular actor from one building to the other. So these all things should be prohibited at the time of advertisements. Next one, Najasvi, please. Right. So guidelines, then I have now come up with the guidelines for disclaimers made in supporting. So earlier we were discussing about the advertisement. Now it's very important that we also, when we are making the disclaimers, we make again put all sorts of put forth all sorts of disclaimers to the viewers so that they make an informed decision. And disclaimers, it's very important that they should not be limited. Of course, ASCI has said that in the recent guidelines which were issued in January 2023, they said that it should be limited to one line. But that's not the particular case, that everywhere where the requirement is such that a particular disclaimer has to be given in 2-3 lines, then adhering to the 4-second requirement, we should definitely give all the particular information which can influence the decision of a particular person. For example, in the ad of this fantasy sports company, if you look at the top bottom, it says that this game involves an element of financial risk and may be addictive. Please play responsibly and at your own risk. So this is one of the classic examples which is being utilized by many of the companies, so that tomorrow there should not be any liability. And if you can see, we see that the ads in the advertisements in the TV of the mutual funds, of the product which is promoted by Mr. Ajay Devgan, the celebrity, they give complete proper disclaimer, so that tomorrow if there is any health hazard or if there is loss or liability on the consumer, it should be pre-informed to them. Otherwise, it becomes our liability. So, so font in this should be same as the one used in the ad. So we should always use in the same language. The disclaimer should always be in the same language as mentioned in the advertisements. So it should be clear and legible. It should not so happen that it is parked in some random corner of our advertisement where no one will be able to pay attention, or the particular size of the disclaimer is such that it is not possible for anyone who is watching it on the TV or the mobile or the tabs or the laptop to actually keep on zooming in. And by the time they zoom in, the 4-second requirement goes off and they are not able to actually understand. So whenever in such cases there is any dispute happens or litigation happens, we need to prove these points as lawyers that we were adhering to everything. It is the consumer who was not attentive while he was going through our advertisements. Next one, please. Yeah. So disclaimers as per the 2023 regulation, it should be kept minimum, but again, it should not be, such that we miss out on giving certain important information. Avoid difficult and complex words. That's very important. If we use very complex words which a general layman do not understand it, then again it is going to be our fault. Not more than one disclaimer at the same time, but again, if we need it, definitely go for it. Restrict to 2 full length lines. This is the guideline being issued by ASCI. Remain on screen. One disclaimer, one line each should remain on screen for more than 4 seconds. And if your disclaimer exceeds more than 2 lines, then please do into account the whole duration. Avoid disparagement. In the example, if you would recall that few years down the line, when the mutual fund ad used to come on the TV, they used to talk really quick. And before one could understand, we were not able to actually register what the person saying on the TV is actually mentioning about. So it's very important that all the kind of advertisements, they are done in a very subtle manner, proper. They should be legible. If it is being read out, that's very good, and it should not be too fast that the person going through it is not able to actually understand. This is one example of the product being endorsed by Mr. Ajay Devgan and Mr. Shah Rukh Khan, wherein they have mentioned everything. That this is in Hindi. It says that this particular product is cancerous. It is available in different colors. This particular kesar is available, is only one of the ingredients, not the entire product is made of kesar, and it is being used as only one of the ingredients. They have drafted this particular disclaimer very smartly. Again, they have covered it in 3 lines instead of 2. But they have done it very smartly to prevent any kind of liability in future on them. Next one, Ojasu. Now coming on to the food safety advertisement and claims regulations. Before this, we were talking from the guidelines being issued by the ASCI. Now we are moving on to the guidelines issued by the rules issued by the FSSAI. These are the certain general principles when we are advertisement of the products. Again, it should not be misleading. and if we are promoting that our particular product is going to give you a certain health benefit, then we need to categorically mention how much serving per container or how much serving per container should be taken every day so that the desired result can be achieved. Like for example, the people who would consume whey protein, they would know that it says that for the desired results, consume 1 scoop of protein powder every day, or depending upon your body weight, because everyone requires 20% of the body weight as protein. And likewise, a simple example of that when I'm saying that when I'm putting up a nutritional claim about my product has a high protein content, then I need to be ensured that the schedule being issued by the FSSAI is properly adhered, and it must have 20% or more than 20% of protein in the 100-gram serving. Then only we can make a legit claim that our product is a high protein product. Likewise, when we are making a claim of no added salt, we need to be very sure that the product should not have any salt or any of the ingredients which have been used to manufacture the product has any added salt. So only when we have a document substantiating the same, such advertisements should be done. And we always need to promote the concept of the balanced diet. We should not say that if you eat a product, you don't need to eat anything, just take 1 scoop or 1 drink a day and your meal is done. And any kind of claim, like in the example which we can see on the screen, is original. When we are saying that our product is an original product, then it should be original, and in the essence it should only be washed or peeled. That is it. It should not be processed at any stage. Then only it is considered as an original product. We should not be saying that, you know, we made this juice, put in some sugar, and then we call it as an original product. Likewise, an example of no added sugar. It is called, when I say that it's no added sugar, I need to ensure that the product does not have any sugar in itself, or any of the ingredients which have been used to manufacture the product have sugar. For example, if we say that this is a plant-based chocolate, and I am actually using jelly to make it sweet, then I cannot make this claim in the advertisement that it has no added sugar. But nonetheless, if the nature of your product is such that it has a natural tendency to be sweet, then you can make a claim that only naturally occurring sugar is in the product. So as a manufacturer, we have not added any sugar. It is only the natural taste of the product is such that it has sugar in it. Next one, please. Nutritional claims. So we could see that, you know, people making claims in the advertisement that our product has low calorie, or it has low fat, high protein soya chunks. I give you a simple example right now. It is trans fat free, no salt, low cholesterol. In such cases, FSSAI can very categorically have given certain rules and the guidelines in this particular rules, wherein they have mentioned certain calories. For example, I think, I'm not very sure though, they have mentioned that if in 100 gram of in 100 grams, if our calorie content is only less than 3 grams, then only I can claim that my product is a low calorie product. Likewise for fat. And if I'm also, and the second type of is the comparative nutritional complaint. You would see on the packet of the Maggi they say that it has 14 times more protein than milk. So this is what we call as a nutritional complaint. But again, when making such claims, we need to be backed up by sufficient documentary proof. Next one, please. So health and dietary requirements which are to be mentioned on the product. So whenever we are promoting a product, like for example, if we say that our consumption of a product will help you prevent heart disease. So we need to be very careful that if we are making a claim, we should never say it will, unless it's backed up by a statutory, by a documentary evidence. We should always play safe, and we may also mention that it may help in prevention, or it is helpful in prevention of heart disease, and we should of the heart disease. But we should not be saying that it is definitely going to procure. We may say that it is helpful, but we should it will procure. And again, making claims like our product promotes bone health, it's a fresh food, it's 100% pure food, and it's 100% original product. All such health and dietary claims, they need to be backed up by sufficiently proof, and it also needs to adhere to the FSSAI regulations also. And very important thing that if we are introducing a brand in the market called or a trademark or a device, and we name it as a 100% pure product, and we let's say assuming in this case it says 100% pure, then we need to give an appropriate disclaimer on the packaging, on all the advertisements, that 100% pure is not the nature of a product. It is only the brand name of a product or the trademark of our company, and not the nature of the product. Next one, ASCI guidelines. ASCI guidelines. So ASCI has issued the guidelines for the influencers. We all know influencers are playing a very big role in the promotion of their product, and sometimes they do it on pro bono basis, or they promote a particular product suo moto, but sometimes they do have material connection with the companies, like in the form of they may be paid compensation for promoting their product on their social media handle, like an example where Miss Amrita Raichand is promoting a particular product. So, and they may be paid some remuneration for that, or maybe free products, or any kind of other compensation or remuneration, a family trip, or free products, a t-shirt or something. That is what when we call a material connection. We need to adhere, or the influencers and the companies, they need to adhere to these guidelines when a material connection, wherein some remuneration is being given to the influencer to promote our products in the market, then this ASCI guidelines will come into picture. Next one, please. Right. So the obligations are here is to disclosure of the advertisement through disclosure label. The disclosure label, as you can see in the previous slide, it said that AD dot. So it says that it's an advertisement and it was in paid collaboration with the name of the company. In the name of the company, the disclosure should be upfront. The responsibility is on the influencer or the publishing account. In case of virtual influencer, the onus is upon the virtual influencer himself and the company both. Next one, Ajasvi. So disclosure label options. These are the certain hashtags which can be used by the influencer when they are, promoting any kind of product on the social media handle. They can use hashtag partnership. They can say hashtag sponsored, promo, collaboration, collab, ad, and no other labels. This is certain 5-6 combinations of the hashtags which have been given, and it also says that this list is going to be periodically reviewed, but as of now, these 5. So if we go on to the next slide, so I've tried to put in 2 examples here, wherein of one from the Beer Biceps and Amrita Raichand. It says paid partnership with Centrum India or paid partnership with Happy Dentin. So it's very important that when we are hiring an influencer, such kind of disclosure is taken care of. It should be an upfront. It should be in English or in the language of the advertisement. It should not be added in the bio or about me or profile. You may add it, but it needs to be conspicuously placed so that anyone who is reviewing that particular ad, he understands that it's a paid advertisement. He need not go to the profile of the influencer and then try to understand, or the bio of the influencer, that okay, this was a paid advertisement. And it should not be buried in hashtags. We see a lot of trend in wherein hashtags of everything and anything is being created online these days. So this particular hashtag of paid collaboration or promo or everything, they should not be buried between the hashtags of the links, and it should be very clearly visible to the consumers. Again, ASCI here also, yes, this slide please. ASCI also has given certain time limits for which the duration of the ad, duration of the disclosure label should be displayed. So if the duration of the ad by an influencer is less than 15 seconds, the duration of the disclosure should at least be 3 seconds. If the duration of the ad is between 15 to 2 minutes, 15 seconds to 2 minutes, it should be 1/3 duration of the ad. And if the advertisement is longer than 2 minutes, it's for the entire duration. And if a live stream is happening or an audio media is happening, then at the beginning of the live stream, the disclosure should be made at the beginning and during each break. And if the particular post or the video is live, even after the end of the live stream, so this particular disclosure about being the paid collaboration should be made towards the end also. Next one, Ojasvi, please. So this is the last part of it. Trademarks. Trademarks, they play a very, very important role in the advertisement sector when it comes to the marketing of the products. So you would, it's very essential that we protect our brand. From day one, we need to do a thorough search if the trademark is available. And most importantly, since we are at the beginning of our business, we need to be very sure that protection of our brand is very important. But at the same time, we need to be very sure that we do not copy someone else's trademark intentionally or unintentionally. Next one, please. So a trademark is, according to the section, I would not try to read the section here. Everything and anything which you see on this bottle can be trademarked. The name Coca-Cola or the logo of Nike or the symbol of McDonald's, the Golden Arches logo, slogan, I'm loving it, the shape of the bottle and the color, orange, they all can be trademarked. So when we are choosing our brand, we should not limit ourselves in understanding that, okay, this particular thing is there, or if I do a particular combination. So you can get your mark registered or protected from each and every aspect. So any or 5 to 6 type of combinations, you can get one trademark registration, or you can get a separate trademark registration depending upon the availability. Next one, please. So again, types of trademarks. So again, Toblerone is there. Toblerone has protected their typical mountain-shaped chocolates. McDonald's has protected their logo. Again, we see that the Asian Paints, they have also protected their logo. Then the design of the bottle is also there, and the color combinations. Companies are trying to protect the color combinations. One of the examples, not from the, I don't have one from the food industry, but what I have is from the automobile industry. If everyone is aware of the John Deere tractors, they have distinct red and green and yellow color combination. So they have protected the color combination of their tractors as a trademark, so that no other tractor company uses the same color combination. Next one, please. All right. Names, logo, symbol, slogan, shape, color, they all can be protected. Next one. Characters. If you are making the characters like the Mickey Mouse, of course, Mickey Mouse is the trademark of Walt Disney. We cannot copy it. The characters, if you have any characters which you have categorically developed in-house and has not been copied from someone else, you can definitely use it on the advertisements, subject to the availability. You can put it on the advertisements, on the labeling, on your website. Shape of the products, I have already given you the example of Toblerone. Packaging, on the packaging or the particular packaging, if you want to ensure that the particular artistic packaging of your product should not be utilized by someone else, you can get a trademark. Combination of colors, one of the example is Standard Chartered Bank also, in addition to Dairy Milk. Next one. Again, when we are choosing the trademark, we need to be very sure that our trademark should not be generic. Generic in the sense that it should not be limited. For example, if I try to protect my brand saying that it's a chocolate, I name it as chocolate, it would not be permitted. The trademark registry is most likely to refuse registration. It should not be descriptive. For example, sugar-free, there is a particular case law wherein it was said that trademark is descriptive. If I am offering sugar which does not have sugar-free in it, it is very much indicative that product is descriptive in nature. So it needs to be a coined trademark which has distinctive element to it. It should not be suggestive of what the products, what services or the products we are selling under this particular brand. It should not be arbitrary. Sorry, it should be arbitrary and not fanciful. So the more the product is arbitrary and not fanciful, like the one Adidas, and the arbitrary, like the Apple, it has more chances of registration and it has a stronger protection vis-a-vis a descriptive or a generic or a suggestive trademark. Next one. So from the desk of the lawyers, always you distinguish your marks from the surrounding text. Always use proper trademark style and spelling. Never modify a trademark to the plural form. Never use a trademark as a verb. Next one. So distinctive and not descriptive. Distinctive and not descriptive, one of the classic example is Google. Google is not describing when it first came into limelight. When we first heard of the name Google, we never thought that this is going to be, it is suggesting some kind of search services. But after so many years, although they are providing search services now in today's era, whenever we want to search anything, we go to Google. That's the #1 platform for most of us to search. And hence this particular brand, Google, has acquired distinctiveness. Name in stylized version, Coca-Cola written in this stylized version. This can be protected. Signature, Sir Donald Bradman, the legendary Aussie cricketer, he has trademarked his signatures. Paul Klee has done that. Invented word, Metro Group trademarked the word autumn, which was coined from their company name Metro. This is an invented word. Arbitrary words like wheel for detergents. So they are not using the word, any word which is suggesting of the word, leading to cleaning of the clothes. So they have utilized the word wheel for detergents. So in no way it is describing what kind of service, what kind of product is it. Exxon for gasoline. So your trademark should be easy to recognize, be remembered, pronounced, spelled, no negative connotations, and not laudatory. Next one, please. Thank you. This was from me. And just on a closing note, from the IP perspective, it's very, very critical that we do a proper comprehensive search, which is available free of cost on the website of the IP India, and do a thorough research on Google, do your general Google search also, so that you're very much confident that we are not infringing or using anyone else earlier adopted logo. Thank you. This is it from me for today. I would not like to just be and ask her to take over from here.